All right, so we're diving into estate settlement today. A little intimidating maybe, but stick with us. We're going to break it down. From the first claim to that final distribution.
You know, the interesting thing here is you're balancing protecting the deceased's wishes, but also fairness for everyone, creditors, heirs. It's a tricky thing.
So first up, claims against the estate. And we've got this thing called the statute of non-claims. Sounds kind of ominous. The deadline, right?
Yeah, and not just any deadline. This is hard and fast. If you have a financial claim, money owed, services, whatever, you have to file it in time. Usually the court sets that. And if you miss it, gone, your claim is gone.
Even if, say, the deceased mentioned a debt in their will, still got to file formally seems redundant.
It might seem that way, but it goes way back. This rule, think about it, claims popping up years later, decades even. The heirs would never be free, always defending stuff.
Right, so it's like, let's wrap things up, give everyone some peace of mind. Okay, so who's in charge of all this? Executors and administrators. I always get those mixed up.
Easy to do. Executors named in the will, they carry out the wishes. Administrator, that's appointed by the court, no will or executor can't do it.
So they're kind of the captain of the ship navigating the legal stuff. But what if the executor wants to make a claim against the estate? Seems like a conflict.
It is. Huge conflict. The courts know this. So they appoint a special administrator just for that claim. Keeps it fair.
Like a referee. Makes sense. Now, big part of this is paying debts, right? Is there like a pecking order? Who gets paid first?
Absolutely. And it's not simple. Funeral costs, final illness, top priority, always. Those are essential. Then things like mortgages, secured debts. Then it's credit cards, personal loans, that kind of thing.
Like Maslow's hierarchy, but for debts.
Exactly. And if there's not enough money, insolvent estate it's called. Things get tricky. Court has a strict list, and unsecured creditors might get just a fraction of what they're owed.
So important to where you stand on that list, huh? Like how risky is it to be a creditor here? Okay, what about the property itself? Can the executor just sell it all off?
Not at all. Selling, mortgaging, anything like that needs court approval, stops shady stuff, protects the heirs.
Checks and balances. Gotta have them.
Yeah.
But why so important? What can go wrong if you don't do it right?
Well, we saw a case. Executor sold property, no approval, sale, void, buyer lost their money, heirs had a mess to clean up.
Yikes. So, point is, you gotta understand the rules, follow the process, can't just wing it with estates.
Welcome back. We're digging deeper into executors and administrators now. Really, it's amazing how much responsibility they have.
Oh yeah, huge pressure. You're basically in charge of someone's final wishes. Gotta do it all right, maybe deal with some family drama on top of it.
It can be, yeah. And the legal stuff's no joke either. For instance, did you know if an executor dies before the estate's settled, their own executor can't just take over?
No. Really? Seems like that makes sense. Just keep it going.
Well, it's about lines of authority, you see. No confusion, no one taking advantage. Each estate needs its own appointed person. The court wants that clear.
So it's accountability, transparency, right person for the job.
Yeah.
Okay, so someone's named executor in the will. What then? Do they just, like, get the keys to everything?
Nope. They need what's called letters testamentary from the court. That's the official go-ahead legal power to act for the estate.
Letters testamentary. Sounds fancy. What does it take to get those?
First off, the will itself has got to be valid. Court needs to know the deceased was sound mind when they made it. All the legal stuff done right.
No.
Can't give power based on something that doesn't hold up, right?
Right, solid foundation check. What about the executor, though?
Yeah.
Any qualifications?
Oh, yeah. They have to be competent, legally speaking. Means they can handle it all. So no minors, nobody who's been declared, unable to manage their own affairs. And they gotta be willing to do it, obviously. It's a big commitment, not something you just jump into.
Can't imagine sorting through someone's whole financial life. Anything else before they're officially in?
One more big thing. Usually they provide a bond. It's like a financial guarantee, protects the estate if the executor messes up, does something wrong. Insurance policy, kinda.
Protection layer. Make sure they're held accountable.
Yeah.
Smart. Now, what if there's multiple executors named, but some can't do it or won't? Whole thing stop.
No, it's flexible. The court just gives letters testamentary to whoever's left, the ones qualified, and they carry on doing what the will says.
Okay, so there's like backup built in. What about if there's no will or the executor can't serve? Who steps in then?
That's when the court appoints an administrator. And there's an order they follow. Usually surviving spouse is first choice. They're often closest to the deceased and everything.
Keeps it in the family. Makes sense. But if the spouse can't or won't, who's next?
Next of kin then. Child, parent, sibling. Court tries to keep it within the family if at all possible.
And if there's just no family that fits, do they, pick a random person?
Not quite. If all else fails, they might go to a big creditor of the deceased, which is interesting. Someone owed a lot of money ends up in charge. And if even that doesn't work, court appoints someone suitable, maybe a lawyer they trust or a professional administrator, that sort of thing.
So always a plan B, C, D. Makes sense. Okay, back to claims for a sec. We know the deadline, got to file on time. But what even is a claim? What kind of stuff falls under that?
Good question. Basically, any money the deceased owed someone else. Debt, contract stuff, even a claim for damages.
So if they borrowed money, or didn't do what a contract said, or caused harm that cost you money, you could claim against their estate.
You got it. Covers a lot. Money owed, funeral costs, last illness expenses, even if there was a judgment for money against them before they died, all that.
Like any outstanding IOU from the deceased, basically.
Mm.
And miss that deadline, it's serious, right? Even if your claim was totally legit.
Yeah, that deadline exists for a reason. Protects the estate, no claims popping up forever, lets the settlement happen smoothly. It's about closure, heirs moving on.
Line in the sand, come forward now or forever hold your peace. But what about claims that come up after the person died? Same deadline.
Most new claims wouldn't be under that statute of non-claims. Couple exceptions, though. Funeral expenses, stuff from the last illness. Even if those bills come after death, they're still valid claims.
Yeah, those got to be paid. That's essential. What about other expenses after death, like for running the estate itself?
Different story. Those aren't claims against the deceased, they're administration expenses. So, not filed formally, the executor or administrator just pays them from the estate's assets, just part of the cost of doing business, so to speak.
Okay, so we're separating what the deceased owed from what it cost to handle the estate. Now, actually paying debts, we talked order of priority, but different situations can change how that works, right?
Absolutely. Solvent or insolvent is the big one. Solvent estate. Enough assets to cover everything. Debts, expenses, even some leftover for the heirs. Insolvent. Not enough to go around.
So solvent, pretty straightforward. Pay up, distribute the rest. But insolvent, who gets paid, who gets nothing? How's that decided?
That's when that hierarchy we talked about really matters. Funeral, last illness, still at the top. Secured debts next, then unsecured. And yeah, insolvent estate. Unsecured creditors, they're the ones who might get the short end of the stick.
So they're kind of gambling, hoping there's enough left after the big stuff.
Exactly. And our sources, they really stress, know where you stand on that list, especially if you're a creditor. Figure out, are you likely to get paid in full? Helps you make smart choices about pursuing a claim.
Managing expectations, understanding the risk. What about more complex situations? Our notes mentioned contingent claims. What are those?
Oh, contingent claims. Those are interesting. It's when the deceased might owe money, but it's not certain. Depends on something happening in the future. Like imagine a lawsuit still going on when they died. Outcome of that could mean the estate owes money, but who knows?
So it's a wild card in the whole settlement. How do you deal with that?
There are rules, thankfully. Court can tell the executor or administrator, set aside some money just in case that claim becomes real, like a reserve fund.
Planning for the what-ifs. Got to do it. All right, let's talk property again. Court approval, super important before you sell it, mortgage it, anything like that. But why that rule? And when would you even need to do those things?
It's all about protecting the heirs, making sure things are done right with the estate stuff. Court's the watchdog. No shady business, no executor or administrator benefiting themselves while the heirs lose out.
Checks and balances, always. But when would they actually approve a sale or something like that? What would make that happen?
Most common reason, paying off debts and expenses. If the personal property isn't enough, they might say, gotta sell real estate to cover the difference.
So lots of debt, house might have to go, tough, but debts have to be paid, I guess.
That's the idea. But sometimes it's not even about debt. Might be better for the heirs to sell, court could allow that too. Or to maintain property or not making much money, selling frees up cash for them.
So not always a fire sale, sometimes it's just smart financially.
Exactly. And other scenarios too. What if the deceased was supposed to sell a property contractually before they died? Court can let the executor or administrator finish that up, even though they're gone.
Like fulfilling their legal duties for them. Interesting. Now, our notes say selling without court approval. Big no-no. The sale can be void.
That's right. Shows you got to do it by the book. Even if you meant well, no court oversight, things can go bad. Buyer might lose their money, heirs have a mess, legal headaches all around.
Good intentions are enough. Follow the rules.
Yep.
And even with approval, I bet there's still steps, right? Not just a free-for-all.
Oh, absolutely. Got to be transparent, fair. Executor or administrator, they file a petition with the court. Here's why we need to sell. Here's all the info about the property. Then there's a hearing. Everyone involved gets notified. The heirs, everyone. It's deliberate.
So everyone gets their say before the court decides. Checks and balances again.
Yep. And the court has leeway how the sale's done. Public, private, they decide. They can even make the executor or administrator put up extra bond just for the sale.
Yeah.
Protecting the estate, making sure nothing goes wrong.
So the court's pretty involved in this whole thing, huh? Like they're the guardians of the estate, making sure it's all above board.
That's a good way to put it. And speaking of protecting things, our next section, we're tackling the final stage. Distribution and partition, that's where the remaining stuff, it's finally divided up among the heirs. Can be a sensitive topic, even lead to arguments, as you might imagine.
Oh yeah, families and inheritances. Recipe for drama sometimes. Can't wait to see how the law handles that. All right, so we're at the finish line of our estate settlement journey. We've tackled claims, executors, administrators, all that. Even debt payments, property sales. Now it's the grand finale. The assets get divided up. If the heirs get their inheritance, distribution and partition, we made it.
Yeah, it's the end of the road, so to speak. And you'd think it's simple, just hand stuff out, right? But it can get really complicated, legally speaking. Family disagreements, tons of paperwork, not as easy as you'd think.
Yeah, I bet. So walk us through it. What's the very first thing that has to happen before any inheritances go out?
First thing's liquidation. Getting a clear picture of the finances. What assets are there? What are they worth? And then paying off all those debts, the expenses, all the stuff we talked about before.
So it's like take inventory, balance the books before you can start sharing the pie.
You got it. Liquidation's got to be done, or the heirs don't even really have a right to anything specific. It's all up in the air till then.
Makes sense. Got to make sure the estate's in good shape financially before handing out money. Okay, so once that's done, how do they divide everything? Is there like a system, or is it just everyone grabs what they can?
Oh no, there's a system, definitely. Legal rules all the way. Usually the executor or the administrator, they make this document. It's called a project partition.
Right. The project partition, we keep mentioning that. That's basically the plan for who gets what, yeah.
That's it. Lays it all out, which heir gets which asset. Looks at the will, if there is one, what it says. And if there's no will, then it's the laws of intestacy, that's what decides. Usually spouse, children, if there are any.
So if the will says, like, Aunt Mildred gets the antique teapot, that's in the project partition.
You got it. And no will. Project partition makes sure things are split up according to the law, keeps it fair, even when the deceased didn't leave instructions.
So it's like a roadmap, this partition thing, guiding the whole distribution. But it's not, like, the final word, right? Someone has to approve it.
Right, one more step. Got to go to probate court. They look it over, make sure it's fair, it's legal, matches the will if there is one, or the intestacy laws if not.
So the court's the referee, keeping everything honest.
Exactly. They say it's good, then that project partition, it's official, it's legally binding. The heirs can finally get their stuff.
Happy ending. Everyone's happy. Case closed.
Usually it is, yeah. But, you know, our sources, they point out sometimes things get messy even after it seems settled.
Oh no, more drama. What could go wrong now?
Well, think about it. What if some heir pops up out of nowhere, wants their share, long after everything's been split up? Or what if there's a debt nobody knew about, comes up later?
Ooh, that'd throw a wrench in the works.
Yeah.
Like a surprise guest at your wedding, but not fun. What happens then? Is it just hopeless?
Not always. The law's got ways to deal with surprises, thankfully. That long-lost heir, they might be able to go to court, reopen the whole thing, get their share, especially if they can prove they didn't know about it before or couldn't participate for a good reason.
So justice can prevail, even if it takes a while.
That's the idea. And those surprise debts.
Yeah.
Yeah, the heirs might end up having to pay even after they got their inheritance. Might have to chip in from their own money based on how much they inherited.
Oof, that's a tough one. So even when it seems over, the deceased's money problems can come back to haunt people.
Yeah. Good reminder that estate settlement, it's not simple. Lots can happen. Gotta be thorough every step of the way.
Agreed. Not something to mess around with. Our notes also mentioned the probate court. They have a lot of power in this distribution and partition phase.
Oh yeah, they're not just looking over your shoulder. They can gather up all the estate stuff, figure out who the heirs are, even decide how much each one gets.
So they're not just watching, they're making sure it all happens right, legally, fairly.
Exactly. And sometimes they can even issue this thing, it's called a writ of possession. It's a legal order, lets someone take control of a property. Like if an heir is being blocked from getting what's theirs, or if there's a fight over who owns something.
So they have some teeth, the
Yeah.
court. They can enforce things if it comes to that.
They can, and that's important. Make sure the estate's settled the right way without dragging on forever.
Well, this has been quite a deep dive. Estate settlement. Who knew it was so complicated? From those first claims, all the way to this final part, distributing everything. It's amazing how the legal system tries to balance everything. The deceased's wishes, the creditors, the heirs, and the court's there the whole time, making sure it's all done right.
It is complicated, yeah.
Yeah.
But knowing how it all works, it helps, right? Whether you're planning for your own estate or dealing with someone else's.
Absolutely. And as we wrap up, here's something to think about. We talked a lot about the legal side of inheritance, but what about the emotional side? Families dealing with all this, it can bring up a lot of feelings. How do you navigate that part? Something to ponder as we finish up our exploration.
Great point. It's not just laws and paperwork, it's people, it's memories, it's a sensitive time.
It is. Thanks for joining us on this deep dive, everyone. Hope you learned something and maybe it got you thinking a little too.